Good morning, everyone, and a very warm welcome to BDB Pitmans' first employment webinar of 2021. For those of you who don't know me, my name's Nick Lariche. I'm one of the partners in our employment team, and today we'll be looking at the key questions and issues which employers need to consider in relation to the COVID-19 vaccine. I'm joined today by a brilliant panel made up of Chris Greek, who in a moment will be looking at the employment aspects of this topic. Oliver Willis will then run through the data protection and privacy issues that employers will need to consider. And Alan Davis will be on hand to answer any of your questions and discuss employers' health and safety responsibilities. Now, I think we're all hoping that 2021 would be a fresh start, but right now I think the year feels like it has a very similar vibe to last year, which we're all hoping to forget. And with COVID-19 cases still so high and the possibility of the lockdown being tightened further, the COVID-19 vaccine, as a best hope of returning to normality, has assumed even greater importance. While at the beginning of December, almost a third of people surveyed indicated that they would be unwilling to be vaccinated, unsurprisingly, given the severe increase in cases in the last month, this figure has fallen to around 15% in recent days. Now, while we might expect this reluctance to be vaccinated to fall further, there are still likely to be a large number of employees who refuse, for various reasons, to be vaccinated. So how are employers conscious of their health and safety responsibilities and anxious to reassure other staff able to manage this situation? Chris will look at possible approaches in a second or two. Before I hand over to Chris, I'd like to cover just a few housekeeping points if I can. At the bottom of the screen, you'll see your normal Zoom functions, and I'd just like to highlight the Q&A function in particular. This is where you can ask questions about what we'll be talking about today, and we'll get a chance to discuss these questions at the end of each presenter's slot and at the end of the session. If there are questions which we haven't had a chance to answer, then we'll send you our responses together with today's slides and a recording of the webinar in the next few days. But I'm hoping we'll get through quite a few questions, and we want this session really to be as interactive as possible. So if you do have any points you'd like to raise, we'd definitely love to hear from you. And just make sure, if you can, to use the Q&A button and not the chat function. You can, though, use the chat function if you have any kind of technical issues, and Sophia and Melissa on our team will try to help you. I think that's all from me on the housekeeping front for now. Thank you very much again for joining us today, and I'll now hand over to Chris Greek to kick things off. Chris, over to you.
Thanks, Nick, and good morning, everyone. Thanks for joining us this morning. And as Nick said, I'm going to be looking at the key employment law considerations of the vaccine and providing some guidance on what employers should and should not be doing. This morning, I'll be looking at a few different areas. So whether employers can require employees to be vaccinated, what action an employer can take if an employee refuses to be vaccinated, some discrimination risks that arise from requiring employees to be vaccinated, whether employers are able to require employees to return to the office once they've had the vaccine, and if vaccinations can be taken into account when considering sick pay. So if we can move on to the next slide, please. And we're going to just discuss some initial considerations of the vaccine. So the key legislation in this area and when considering the vaccine is the Health and Safety at Work Act 1974. This obliges employers to take reasonable steps to reduce any workplace risks. So I think it would be fair to say in the first instance that employers should be encouraging their employees to be vaccinated in order to protect themselves and everyone else that's in the workplace. The first thing that employers should be considering at the moment is their workplace risk assessments that should be in place. These will need to be amended to reflect the availability of the vaccine when that's being rolled out a bit more widely. The risk assessments will also need to be clear on what additional measures may be in place if an employee does choose not to be vaccinated. This may be the requirement to wear PPE where others may not need to do so. So you can move on to the next slide, please. So I'm going to just talk about whether it can be mandatory for employees to get the vaccine as a health and safety requirement or as part of policy by the employer. And it's an area where there is a lot of debate at the moment, and I don't think there is a cast iron answer that can be given on this. I think what we need to do is break it down into different elements of whether it could be acceptable and where it might not be. And whether it's going to be acceptable or not is whether the policy to get a vaccine is a reasonable management instruction. Now, where the Health and Safety at Work Act obliges employers to take reasonable steps to reduce workplace risks, one way that employers will look to fulfill that obligation is to ask employees to be vaccinated. Employees also have a duty under the Health and Safety at Work Act to cooperate with their employer so that the employer can comply with that duty. So what we need to determine is whether that request to get the vaccine is reasonable, and that will depend on a number of different factors, which include the nature of the job, the workplace environment, and the availability of other measures. So a request to be vaccinated is more likely to be reasonable where employees are at a higher risk of being exposed to the virus, such as in a care home or a hospital. I think where the risk of exposure is lower, then the request is going to be less likely to be reasonable. Something that is important to bear in mind when discussing this is the fact that the government have confirmed that the vaccine is not mandatory. It is an individual's choice. And this is important when bearing in mind that the government are the largest employer in the healthcare sector, and there is no requirement on healthcare staff to get the vaccine. So those working on a COVID ward or in the ICU, there's no requirement on them to have the vaccine. It still remains a choice. That might be something that the tribunal give some consideration to when assessing reasonableness, in the fact that if the highest risk areas are also maintained that it's a choice, is there something more that employers could do that as a different measure that falls short of the requirement to get a vaccine? I think seeking to rely on a refusal to get the vaccine as grounds for a health and safety breach by the employee, or as grounds for any type of disciplinary action or potentially dismissal, is going to be quite a risky course of action to take, given the point earlier about the government mandating the vaccine is a choice. And I think the fact that a large number of employers were able to reopen their offices earlier in 2020 during the summer, after the first lockdown, they were able to work risk assessments in ways that were able to provide safe and COVID secure workplaces. So there are some measures which are available to employers that are short of requiring people to get a vaccine that allow for a safe working environment. So the issue, as I've mentioned, is whether the request to obtain the vaccine is going to be reasonable, and if that refusal to then get the vaccine is going to be unreasonable. And this is going to come down to the individual workplaces, and the tribunal is going to assess each case on its own facts. And so it needs to be something that is very carefully considered in each individual workplace before implementing a policy or before trying to take action against an employee who has refused. At the moment, the vaccine is still very fresh. It's not something that has been tested yet in the employment tribunal, and so we don't really know what the employment tribunal standpoint is going to be and which side of the fence they fall down. And it's something that I think is going to be tested in the near future, most definitely, and something to definitely keep an eye on. But I think the key point here is to really assess the workplace and whether there are any measures that are available to you before implementing a policy mandating that an employee has to be vaccinated. So if we go on to the next slide, please. So what's the scenario where an employee refuses to get the vaccine? The first thing to do is to understand the reasons that each employee does not want to get the vaccine. That's a really important step that needs to be taken. That you need to be then discussing the concerns with employees, with any relevant health and safety representatives and any trade union representatives. And I think you need to be explaining why the vaccine is important to their health and safety, to the health and safety of others in the workplace, and also the health and safety of their families. If they're going into the office, they're more at risk of catching the virus or transmitting it to their own families. I think when you're having these conversations with your employees, it would be sensible to have information from credible sources, which may help alleviate any misinformation they received from some perhaps incorrect sources, where misinformation may have been spread about the virus, which about the vaccine rather, and that may then help alleviate any mistrust or anxiety that an employee has in the vaccine. Having a blanket policy that all employees must be vaccinated before returning to the office is going to expose employers to potential discrimination claims. There's going to be a number of different reasons that employees will refuse to get a vaccine, and a number of those reasons may be relating to a protected characteristic under the Equality Act 2010. So there's some religions may discourage some vaccines because of some of the ingredients. Some ethical beliefs, such as ethical veganism, would discourage some vaccines because of their use of animal-based products or the fact they've been tested on animals. Some illnesses which could be covered under the Equality Act as a disability may prevent employees from getting the vaccine, and so obviously that they wouldn't be able to get it for that disability-related reason. There are also going to be some employees who are pregnant or maybe planning to get pregnant, and they won't want to get the vaccine for that reason. I think the COVID-19 vaccine at the moment it's advisable. It's advised that women who are planning to get pregnant or who are pregnant don't obtain the vaccine. So there are lots of things to be considering when trying to implement this policy, and again, understanding the reason that an employee doesn't want to obtain the vaccine is going to be very important. If you were to try and implement that policy completely against every single employee, I think there's going to be claims coming at your door for various types of discrimination. So if it's for someone who has refused the vaccine on religious or ethical grounds, then it's highly likely that indirect discrimination claim is going to be landing on your doorstep. The good thing about an indirect discrimination claim, if there is such a thing, is the fact that it can be defended. So it can be defended where an employer has a legitimate aim that they're trying to achieve, and the way they achieve that is proportionate as a means of achieving that aim. I think in this situation, the legitimate aim would be the employer's duties under the Health and Safety at Work Act to reduce workplace risks. The issue that some employers will face is whether the policy of requiring an employee to get a vaccine is proportionate in achieving that aim. And as I mentioned earlier, the fact that a lot of companies were able to return to office working without the vaccine and with a risk assessment in place that reduced the risks of transmission of the virus to ensure a safe working environment, that's something that a tribunal will look at and assess in quite some detail when looking at whether enforcing a vaccine on employees is a proportionate means of achieving the legitimate aim of reducing the workplace risks. I think the same is going to be said for any claim that is brought on the grounds of disability. So likely to be a Section 15 of the Equality Act claim for something arising from a disability. Again, that is something that can be objectively justified in the same way as an indirect discrimination claim. So it's going to be objectively justified by having a legitimate aim that is and the actions you've taken is proportionate means of achieving that aim. It may be possible then to think through other ways of ensuring the safety of those who have been vaccinated and those who haven't. And it may be that a policy is then put in place for those who have been vaccinated to return to the office, and those who have been unable to get the vaccine for whatever reason remain working from home, and that's something that may be justifiable on the same grounds. You would look at the legitimate aim, again, the aim of protecting those in the health and safety of all the employees in the workplace, and then you're looking at the proportionality of that measure, and that may be more proportional in the circumstances by allowing them to continue to work from home than by then forcing them to get a vaccine which may be against a religious belief or against medical advice. So if we can move on to the next slide. I'm just going to consider some other issues that may arise from this vaccine in general. I think there are lots of people who have a general viewpoint against vaccinations, so that the anti-vax beliefs, and it's worth considering whether these beliefs, so a general view against vaccinations, could actually be protected under the Equality Act as a philosophical belief in its own right. In order for that to qualify as a belief, it must be genuinely held. It must be a belief, not an opinion or a viewpoint. It must relate to a weighty and substantial aspect of human life. It must attain a certain level of cogency, seriousness, cohesion, and importance. And it must be worthy of respect in a democratic society. So there may be differing reasons under those. I think some people may argue some points more than others, but I think the main reason that we feel that it's unlikely that these views will be protected is because of a judgment in the case of Conisbee and Crossley Farms. And this case was quite interesting, and it considered whether vegetarianism could be considered a philosophical belief worthy of protection, much like the way that ethical veganism has been found to be worthy of protection. In this case, the tribunal found that because of the wide-ranging reasons that people become a vegetarian, many different reasons for them doing so, that it shouldn't be protected. And I think the same principle is going to be applied to these anti-vaxxer beliefs. There's lots of reasons that people hold the views. So whether it's a bad health reaction, religion comes into this, distrust of big pharmaceutical companies. And I think the most recent one is the fact that Bill Gates is trying to track everyone with a microchip. So lots of various reasons that people become to have and hold these beliefs. So I think that the key point at this stage is again to then, if they're having a general view against vaccinations, is understanding that reason, having the conversation with them, and then it becomes an assessment of whether this is a reasonable management instruction to get the vaccine, and you're back to the starting point of whether it's reasonable in these circumstances, taking into account the risks that are there, the workplace environment, the nature of the job, and the availability of other measures. So a topic that a lot of people have asked about is, when an employee has been vaccinated, is there an ability on the employer to require them to go back to the office? So employees are protected from suffering from any detriment or dismissal if they refuse to return to the workplace because they have a genuine and reasonable belief that there may be a serious or imminent danger to their health and safety. I think where they've been vaccinated and an employer has already got in place a workplace risk assessment setting out a number of different ways of preventing or trying to prevent as best they can the transmission of the virus, then it's going to be difficult for an employee to raise concerns about the health and safety that can be reasonable in those circumstances. I think again the conversation is the result of the situation is to have a conversation with them, advise them clearly, and communicate with them the steps that have been taken to protect their health and safety in the workplace. And I think it would be fairly unreasonable for an employee to refuse to return to the office if they've been vaccinated, and if there is a policy and a risk assessment in place that allows for them to return safely. I think sort of following on to that point, I think one thing that will come from a requirement to return back to the office is a wave of flexible working requests. I think lots of people will have enjoyed working from home, and they've been able to work from home successfully, and so it's something they'll like to continue doing, whether that's for the whole of the working week or for part of it. And so a number of flexible working requests are going to be likely. And it's important to remember that those requests will need to be considered on a case-by-case basis, and any rejection of that request needs to be one of the prescribed reasons if the flexible working request meets the statutory requirements. So then another point to really cover is sick pay and the effect of the vaccine on whether an employee will be entitled to sick pay if they refuse to get the vaccine. I think in terms of statutory sick pay, I think it's likely that the government will turn around and say that it's not possible to claim SSP if you've refused the vaccine, given that the government themselves have mandated that it's a choice to be able to get it. If there is contractual sick pay in place, it's in the contract that they will receive 2 weeks pay if they're off sick. If they follow the requirements set out in the policy, then I think it's going to be difficult for an employer to refuse to pay them, even though they have taken the vaccine, have not taken the vaccine, excuse me. If there is a discretion in the policy, then it may be something that employers want to look at, and they want to look at potentially carving out whether the fact that they haven't had a vaccine and then contract coronavirus is something that employers will refuse to pay or exercise their discretion for under the policy. Again, you need to bear in mind at this stage the reason they haven't got the vaccine. So if that is in relation to a protected characteristic, you may be exposing yourself again to any a discrimination claim if you're refusing to exercise your discretion at that stage. At the moment as well, I think a lot of people have been wondering whether if employers can give the vaccine or if they can purchase the vaccine for employees. At the moment, it's not commercially available, and so it can't be purchased by employers to be given to the vaccine. If it comes to a stage where the vaccine is available and employers require employees to be vaccinated, then it's something that the employer should be paying for. And it is worth bearing in mind, depending on the cost of the individual vaccine, whether that then becomes a taxable benefit. So I think those are the other issues that I think need to be considered when looking at it. And I think that's everything from me, Nick.
Fantastic. Thanks very much, Chris. We've had a few really good questions being asked as you've been speaking. So let's just kind of have a look at some of these. Just picking up on some of the points that you were talking about in relation to requiring people to come back to work once they've been vaccinated. Could you see there being kind of risks of age discrimination claims if you're requiring staff to come back to work, given that at the start probably it will be older employees who've had the vaccination rather than young employees? Do you see there being a potential risk there as well?
Yeah, I think that is something that will need to be considered. I think it's important to consider all aspects of any protected characteristic when looking at a blanket policy. Look at who could potentially be disadvantaged by that policy, and taking steps to make sure that that doesn't happen, or if there is any indirect discrimination claim that comes in, be thinking about the legitimate aim and whether the actions you're taking is proportionate. Are there any actions that can be taken that fall short of that? And then yeah, something that does need to really be considered when looking at these types of policies.
Brilliant, thanks very much. And we've had another question about what happens if you have clients who you work with in the care sector and they make a request that your teams are vaccinated in order to work for them. Do you think that would be kind of a reasonable request, and how do you think people should kind of manage situations where there's a kind of a client almost demands that their staff are vaccinated?
Yeah, I think that's quite an interesting situation that I think it may arise in the future. I think whether that is reasonable, I think will come down to the individual circumstances of the health and safety assessments that may be in place in those individual care homes. So looking at what is in place and saying to that client that our employees aren't mandated to get the vaccine, and they are able to follow your workplace assessment and be safe in that environment, which but probably a very difficult situation for some employers. I don't know what your thoughts on that might be.
Yeah, I think it could be a matter of again discussing the situation with the staff as well. I think if there is scope, to maybe reorganize teams if there are particular individuals who feel kind of strongly against being vaccinated, and they're working for clients who demand vaccination. Again, maybe you're getting into a more reasonable request if there is client pressure. Again, it's not your demands, it's something that's almost kind of imposed on you in order to carry out your business. I think if you are going to do that route, you probably expect a tribunal to want to see some evidence of at least you having explored the scope of that demand with the client first before agreeing to it. So again, you haven't just accepted it completely, but you've explored it and maybe push back to some extent if you feel able to do so. So I think that's worth kind of considering. But I think it does place employers in quite a tricky position when they do have clients, making those type of demands. And we've also had a question from Criticaler about what do you say if someone doesn't want to be vaccinated and they want to continue working from home forever? You were kind of mentioning about flexible working requests, but I guess that's something we might see as well.
Yeah, I think that's what's likely to happen is a lot of people are going to make those requests if they've been able to work from home. And I think it just comes down to then a decision for the employer if they're happy with the output that the employee's been doing, if they've been working from home successfully and they're happy to do that, and if you're happy for them to do it, then there shouldn't really be a problem. It's just confirming that and any changes that need to be made in any relevant contracts and ensuring policies are up to date for working from home and those sorts of issues.
Yeah, absolutely. And again, we had a question from Nikki about, you were talking about sick pay and employers' abilities to kind of to qualify that in relation to COVID-19 vaccine cases. I think this is a point that you and I were chatting about yesterday, which is, if you have a contractual sick pay policy where there's a requirement that it won't be paid if the employee has behaved recklessly, so going skiing or doing other kind of dangerous activities. Do you think there's a kind of a similar analogy that you could apply to COVID-19 cases as well?
Yeah, I think so. I think that was the sort of thinking that I had behind it as well. The if you are being reckless, you're doing something where there is a risk of injury by doing that course of action. So the same could be said for skiing. You're going skiing knowing that you are potentially going to get injured, and you're taking that risk regardless. And with the vaccine, you are aware that there is a risk that you contract the virus, and you are again deciding to take that risk. But as I said during the presentation, with this, you do need to be very aware of the reason that the employee hasn't got the vaccine, whether that is going to be protected under the Equality Act, their reason behind it. If they're just having the general anti-vax belief, or they think it's Bill Gates trying to track them in a microchip, then that might be a reason that you can decide not to exercise any discretion under the policy.
Yeah, absolutely. And again, I think it's important that you've kind of flagged that position up to employees in advance before you're starting to implement that type of change. It's obviously got to be communicated thoroughly to staff before you're starting to impose it. I think that's a very important point. We've had a lot of kind of questions as well, which are kind of getting into Oliver's area. So I think I'll now hand over to him to look at the data protection and privacy angle of this situation, and then we can pick up some more questions after he's spoken. Oliver, over to you.
Great, thanks, Nick. So if we could just move on to, yeah, that's great, the next slide there. So I think one of the things that comes out of everything that Chris and Nick have said is that if you're going to be implementing any sort of policy around employees and vaccinations, logically, you're probably going to end up having conversations with employees about whether they have or haven't been vaccinated. And in many instances, to be able to effectively implement a policy, you might need to start keeping records of who hasn't or hasn't been vaccinated. And of course, those records are going to be personal data relating to those employees. And that raises data protection issues, which I'm going to be talking about now. Before I do, though, I should say that this part of the webinar comes with a couple of health warnings, if you'll excuse the expression. The first is that the ICO has not yet published any guidance directly dealing with vaccinations. For obvious reasons, we've not had any court cases dealing with data protection issues in this context yet. I think until we get some more guidance or those court judgments coming through, we're going to see a range of different views and different approaches in this area. I think the second health warning is that the correct legal approach is going to very much depend on the factual situation for a given workplace. And, you know, when we're thinking about, you know, how you might be able to use information about vaccinations, it's always going to have to be led by that factual situation more than anything else. So with that in mind, what I'm going to do is just run through some of the key data protection principles that apply in the context of information about vaccinations. Then I'm going to highlight some of the guidance which is being published in other contexts, which I think could potentially be relevant here. And then I'm going to look at some of the practical issues which employers should be considering before they start using this sort of personal data. I should also say that given the audience, I'm assuming probably some basic familiarity with the data protection regime. So I am going to be focusing more on the issues that specifically relate to information about vaccinations and health. So where do you start thinking about this sort of issue? Now, clearly information about vaccination status is going to be a new type of personal data for most employers. But having said that, almost all employers will be used to holding a certain amount of health data about employees already. So, you know, that could be in the context of managing sickness absence, things like maternity leave, recording injuries in the workplace, or information about disabilities for the purpose of making reasonable adjustments. So the core set of obligations around managing employee health data hopefully should be familiar to most employers already. And really what we're doing here is considering how those familiar obligations apply in an unfamiliar situation. So if we could just move on to the next slide, I've got a couple of starting questions here, which I think are probably where you ought to be starting. So the first one, crucially, what information are we going to collect? And depending on the nature of the policy that you're trying to enforce, that might range from you know, something like simply asking employees to notify you if they do get a vaccination, through to potentially something more detailed. You know, Chris mentioned the importance of understanding why employees might be concerned about getting a vaccination. So, you know, if you're starting to collect that sort of data, you're potentially going to end up with a broader set of data relating to vaccinations than you might otherwise. So you're going to need to decide what data you actually need. The second question then is going to be, what are we going to do with the information? And really that's going to be led by the type of policy that you're looking to put in place. So, you know, if you are looking to put in place a policy that involves people coming back or being asked to come and work in the office again once they've had a vaccine, you know, might be able to limit that quite a lot. You might be able to say, well, actually, all we need is for someone to give us that confirmation, and then we can put that employee's name on a list of people who are cleared to come and work back in the office, and that's it. We don't really need to do anything else with the information. Conversely, if you're talking about a situation where you're potentially, for example, the context where you're dealing with clients who might have requirements around employee vaccination, the possibility of having to share with your clients whether employees have been vaccinated is obviously using that data in potentially a more complex and potentially more risky way. So you need to really clarify what it is you actually want to do with the data. And once you've answered those questions, then the next sort of more legal compliance question is going to be, does that plan fit with the conditions for lawful processing under the relevant legislation? And that's what we're going to move on to now. So you're probably all familiar with the need to have a lawful basis for processing personal data. And of course, here, because we're dealing with health data, as well as having your sort of basic lawful basis for using the data, you're also going to need to make sure that your processing of that data satisfies one of the additional conditions for processing health data, also sometimes known as special category data. So if we move on to the next slide, we've got a couple of options here which are going to be worth considering. Now, as I said, the ICO hasn't released any guidance directly on vaccinations, but they have released guidance on COVID-19 testing. Particularly that's aimed at employers who might have been thinking about putting in place a testing service for their employees. And I think that guidance has quite a lot that's relevant to the vaccination context as well. And in that guidance, the ICO has identified a couple of different special category conditions which might apply and which I think could potentially apply to vaccinations as well. So the first of those conditions applies where your processing of the data is necessary for the purpose of carrying out obligations and exercising specific rights of the controller or of the data subject in the field of employment, insofar as that's authorised by UK law. Now, this ties into what Chris was saying about employers' legal obligations under the Health and Safety at Work Act. You know, that's a set of obligations in the field of employment law, and if you are in a position where you've carried out your risk assessments and you've concluded that it's necessary to hold information about vaccination in order to comply with those obligations, then potentially you might be able to satisfy this particular condition for processing special category data. The second condition is slightly more complex. It applies where the processing is necessary for reasons of public interest in the area of public health. Now, in the ICO's guidance, the ICO has pointed out that in the context of testing, there are obligations to share test results with Public Health England, who monitor that data as part of the national response to the pandemic. In the context of vaccination, we've not seen anything yet that suggests that there would be a sort of obligation for employers to share that sort of information with Public Health England. But the concept of public health is still quite wide in the legislation. So potentially the idea that you're using a policy around vaccination to try and restrict the spread of coronavirus in the workplace, or potentially with other people who your staff interact with, and that could potentially fall within that scope of public health. However, you'll notice on the slide there that this condition also includes a requirement for a public interest. Now, the ICO's issued separate guidance in other contexts on this idea. And what they've said there is that public interest means something beyond the interests of the employer and the individual employee. So in my view, employers that want to be able to rely on this public health condition ought to be able to demonstrate that the data processing is motivated by the need to protect the broader public or to protect services which have a broader public importance. So for instance, an employer might be able to show that if the employer was providing health or social care. And if we were talking about employees who needed to have close contact with patients or other members of the public in order to provide those services, that's the sort of context where an employer might be able to demonstrate that there was a public interest here. By contrast, if we're looking at a situation where your policy on vaccinations is focused on the needs of the business in terms of, for example, being able to reopen offices, that in itself isn't likely to be enough to constitute a public interest, even though, in day-to-day speech, we might all think, well, wouldn't it be great if businesses were all able to get back to business as usual? So that's, if you're thinking of relying on the public interest condition, that's something that's going to have to be thought about quite carefully. The other thing to say about the public health condition is that you can only rely on it if the information that you're processing is being processed by or under the responsibility of a healthcare professional or someone who owes a legal duty of confidentiality in relation to that data. So you're going to have to be very careful about how you structure that data processing to make sure you're able to satisfy that obligation. Final thing to say on these two potential special category conditions is that you'll notice that they both apply only where the processing is necessary for the relevant purpose. And if we move on to the next slide, I'm going to talk a little bit about how you can decide if the processing is actually necessary. And again, I'm looking back to the ICO guidance on COVID-19 testing, which sets out the questions that you've got on the slide there and suggests that employers need to ask themselves those questions in the context of testing. I think these are good questions to ask yourself in the context of vaccination if you're developing a policy on this. And hopefully from the slide, you can see that these questions are getting at some of the points that Chris raised earlier. If an employer can meet its health and safety obligations through alternative steps around remote working, social distancing in the office and so forth, then processing information about vaccinations is unlikely to be necessary. You'll also see from the questions that the ICO is suggesting drawing a distinction between employees who are in high-risk roles, where you might need to know more about their vaccination status, compared to employees who are potentially in lower risk roles, where it might be harder to show that having that information is actually necessary. If you look at the final slide, the final question on that slide, you'll also see there that the ICO is suggesting thinking about the scope of how far this data gets used in the business. So it might be necessary for certain staff within the business to use information about vaccinations, but not others. And I think it's worth keeping in mind on a practical level, the wider that information is disseminated within the organization, the more people who have access to it, the more that's being done with it, the harder it will be to demonstrate that all that processing is necessary. And when we talk about necessity, here we're really looking at, is this a proportionate way of achieving the aim? Particularly given that holding information about health is inherently quite intrusive into an employee's privacy. And if you're coming to the conclusion that actually there are other steps that you could take to achieve your end purpose, whether that's reopening the office or keeping employees safe, then you're unlikely to be able to show that holding that vaccine information is proportionate. So thinking about that then, what other steps do employers need to consider? So for employers who are able to satisfy those legal conditions for processing, there are of course other compliance issues to consider. And if we move on to the next slide, I've given you a very brief list of some of the key ones. So the first thing, and this is a practical as well as compliance question, is to think about how you're going to collect the information that you need about whether employees have been vaccinated. And in particular, whether you're going to be asking employees to provide any evidence of that. Because, you know, we can imagine one approach would be just to ask employees to say, yes, I have been vaccinated, no, I haven't. Another approach might be to ask employees to provide some sort of evidence, some sort of independent evidence that that's happened. At this stage, it's not entirely clear what independent evidence a person might be able to provide for that. But certainly, at the point an employer is starting to think about asking employees to provide, you know, letters from GPs or things like that, you're potentially, in doing that, going to end up collecting quite a lot more information about that employee than you might necessarily want. And that's going to make it much harder to demonstrate that what you're doing is necessary. It's also worth keeping in mind that the legislation prohibits anyone from requiring another person to make a subject access request. So you can't say to an employee, you've got to make a subject access request to obtain the medical record that shows you that you've been vaccinated. The second issue, once you've thought about how you're going to collect the data, is thinking about how long the data is going to be retained for. Now, there's a general legal principle under the legislation that data mustn't be kept for any longer than is necessary, taking into account the reason for which you've collected it. Now, obviously, that is going to vary depending on exactly what policy you're applying. But to go back to one of the earlier examples, if you're thinking about how you can make a workplace safe, and really you're only interested in, at a point in time, has an employee had a vaccination or not, you might not really need to keep that information for very long, or at least you might be able to delete bits of the information at quite an early stage of the process. The other thing that employers might need to think about here is, you know, how long does the vaccine provide protection for? And certainly once there's more reliable information and guidance published around that, that might have an impact on thinking about how long you would keep information about someone's vaccination status. If it emerges that the vaccines only provide protection for a certain period, then keeping the information beyond that period is going to be harder to justify, because the information becomes out of date and it's not really serving its core purpose anymore. The next thing that you need to consider, and of course this goes for all personal data, is how you're going to keep it secure, both on a technical level and also in terms of organizational controls on who's got access to it within the organization. And I think the point to keep in mind here is that because of the sensitivity of health data, the potential consequences of getting that wrong are much more severe for the individuals. It's potentially much more intrusive. So the security measures that you take will need to be stronger to reflect that. And it may be that in this context, the ordinary measures that you have need to be re-examined, potentially expanded or made more stringent if you're going to be collecting this new type of data. Again, like all other personal data, employers have a duty to provide certain privacy information to employees explaining how the data is used. And given that information about vaccines is probably going to be quite a novel sort of information for most employers, it's unlikely that existing privacy notices are going to have adequately explained this sort of situation. So employers are either going to need to go back to the existing notices and update them, or potentially circulate separate notices which deal with the vaccination issues specifically. And I think my own view would be that the latter is probably a better way of dealing with it, because if you're setting up this policy, you're going to want to communicate about the policy from an employment law perspective. You may as well take that opportunity to make sure you provide the information which the legislation says you need to about how you're going to use the information supporting the policy. Again, just like other personal data, your employees are going to have rights in relation to their data, particularly the right to request copies of it. So employers who are going to start collecting this data also need to think about whether they are set up to respond to requests for those rights. I think one of the things that we've noticed more and more over the last couple of years is that where employees are uncomfortable about things that are going on in the employment relationship, it's increasingly common for them to start trying to exercise their information rights to find out information that's being stored about them. I think given that some of these vaccination issues might have a bit of controversy around them, it would be sensible to expect that you might need to handle more subject access requests or other similar requests in relation to this data, and to make sure that you've got steps in place to resource that properly. Where employers are relying on the employment law special category condition, which we talked about earlier, there's also a need to have what's known as an appropriate policy document in place. Now, that's a document which explains the employer's processes for complying with the core data protection principles in relation to the employment law condition. And it also explains the controller's policies regarding retention and erasure of the personal data. So it's a document which most employers should have already in relation to the health data that they hold about employees. But again, because we're talking about a new situation here, it will be important to go back and check that and make sure that it accurately reflects what's going on in this new situation. The last issue which I'd like to highlight is the potential need for a data protection impact assessment. So for those not familiar with these things, a data protection impact assessment is a bit like a risk assessment in a health and safety context, except that it's focusing on assessing risks involving data processing. It will be a document that examines those risks, considers necessity and proportionality of the processing, and documents your risk mitigations. They can be a very useful tool for documenting how you've dealt with some of the other issues that I've mentioned. But more importantly, the legislation does make those assessments mandatory before undertaking any processing that's likely to result in a high risk to the rights of the individuals involved. And depending on what the employer is planning to do with the vaccination information, I think it's very likely that that risk threshold is going to be reached. And so you will need to have that data protection impact assessment in place before you start using that data. So hopefully I've given a useful starting point for navigating some of the data protection issues around COVID-19 vaccinations. Obviously, we can talk about specific questions now as part of the Q&A. And if you'd like to have a look at any of the guidance that I've mentioned, it's on the next slide, which of course will be circulating after the talk. So with that, I'll hand back to Nick.
Brilliant. Well, thanks very much, Oliver. Much appreciated. Yeah, we certainly have had quite a few questions coming through on some of the points that you've talked about. That we've had a few questions about whether employers can insist on people disclosing whether they've been vaccinated, or the extent to which they can keep records or a log of vaccinated staff. Again, that will probably come back to the legitimate interest or the reason why that information has to be processed. Is that right?
Yeah, absolutely. I think the thing that's really important to keep in mind here is that it won't be lawful to keep that kind of information on a just in case basis. So before you start asking for that information, or indeed telling staff that they have to provide the information, you need to have gone through a proper process of working out why you need it and what the lawful basis for holding it is. Because I can well imagine that there may be staff who feel that is intrusive, and I think employers who kind of jump the gun and start asking for that information without having really thought about these issues are potentially exposing themselves to claims from those employees and potentially regulatory action as well.
Great. I think you touched upon as well, I mean, asking individuals for evidence of COVID vaccinations and the difficulty with that. Again, you would really have to have, you know, very strong grounds for wanting to, I guess.
Yeah, exactly. And I think the other thing that's worth keeping in mind is, even if you're asking for evidence at one stage in the process, do you actually need to retain that evidence? You know, if you felt that you were legally able to justify, for instance, asking an employee to provide a GP's letter confirming that the employee's been vaccinated, is there really a justification, once you've seen that letter, for keeping the letter itself? Or you know, could you achieve the same outcome by seeing the letter, making a note in whatever system you're using to track all this, that you've seen acceptable evidence, and then safely destroying the letter?
And I guess, again, we've had a question about kind of anonymous staff surveys about whether the staff have had vaccinations or their intentions to be vaccinated. I guess that would be slightly less intrusive, because you're not necessarily holding personal data about individual staff. You're just seeking kind of general information about people's intentions on an anonymous basis.
Yeah, that's right. So, of course, anonymous data isn't personal data at all. So it doesn't raise the same data protection issues. There are a couple of practical cautions around that. The first is that sometimes there can be a bit of confusion between what's anonymous data and what, in sort of data protection jargon, is pseudonymous data. Pseudonymous data is data where you've collected it and you've perhaps taken out obvious identifiers like names, but you've replaced them with something like, you know, a unique number, and you separate the list that has got the names and the unique numbers from the other information, but with the intention that at some stage in the process they can potentially be recombined. If you're going to plan some sort of anonymous survey, you really need to make sure that what you're doing is genuinely anonymous, and that it's not a pseudonymous exercise where you know, you're able to pick out individual responses and put them together with other data, which might re-identify the individual. So absolutely, if you're able to manage that survey process in a way that it's genuinely anonymous, then that's not going to raise these data protection issues.
Great, thank you. And how about employers who have large numbers of staff traveling abroad? Would processing of vaccination information there fall into a public interest condition, or would that only apply if kind of the COVID vaccine becomes a condition of travel?
Well, the public health point might apply there, depending on what the kind of legal controls are on people leaving the UK and entering the countries where those staff need to work. You might be relying on the employment law condition if the employer has a direct set of legal obligations. But I think, you know, the other approach that an employer might want to think about there is, you know, if another country has rules about people needing to have had the vaccine before they enter, and those rules place direct legal obligations on people at the point of entry, it may be better from the employer's perspective to make sure the employees are fully informed about those rules, and then to say, actually, to the employees, it's your responsibility to make sure that you've complied with those rules, and, you know, here's how you can do that. But for the employer not to necessarily insert itself into that process. Obviously, that will need to be balanced against employers' duties around safety of their employees, and thinking about whether taking an approach like that puts the employees at risk.
And actually, I just wanted to bring Chris in on the kind of the related point there, because I guess there could be greater scope to require staff to be vaccinated if, as part of their role, they do travel a lot, overseas for work. And obviously, we can see down the line it could be a condition of travel or entry into some countries that individuals have been vaccinated. So Chris, I don't know what you think, whether in those kind of conditions you might have a kind of a greater justification to say to staff, well, look, in order to be able to do your job, you need to have been vaccinated.
Yeah, I think so. I think that's going to be likely. I think, again, it will all come down to the reason that they've decided not to get the vaccine. If it's a health condition, they physically can't get the vaccine, then I think you're going to be looking at doing other things to try and maybe change their roles so that they can do something else and the requirement to travel is taken off. So I think that there's other measures that can be taken, again, that's short of just dismissing someone because they haven't got the vaccine. But I think I think that the most important point with all of this is the reason behind the vaccine hasn't been taken.
No, excellent. Thanks very much. Well, just before we finish today, I do just want to get Alan Davis's view on from a health and pure health and safety perspective. We've had some questions about, steps that employers can take in terms of seating staff who have been vaccinated, kind of office-based measures kind of flowing out of vaccination. And I'm just wondering what your kind of thoughts are on this would be.
Yeah, hi. Well, as a general observation, employers need to be aware of their obligations to ensure the continuing health and safety of their employees. And as a reminder, the employers have to make a declaration that their workplace is COVID secure. I expect you'll all remember the 5 steps to working safer together, and the declaration that needs to be made by the employers that the workplace is actually safe. So they've shared the COVID-19 risk assessments with the workforce, and they've done everything reasonably practicable to ensure that the workplace is safe. And as part of that assessment, I think it's important that the employers consider the extent to which their existing COVID-19 risk assessments need to be updated. And one of the one of the hazards, rather, firstly, in the assessment process is the transition risk within the workplace if there is a return to the workplace, and there's an obligation to consider the appropriate control measures in place to minimize that risk. And one of the control measures, a new control measure to be considered in this whole process, would be the extent to which the workforce has been vaccinated. And so as part of that traffic light risk assessment process, with red for danger, amber that needs further consideration, and green, which is acceptable, that's an additional factor that needs to be considered and worked through in the assessment process. And if that sort of assessment and general consideration is not undertaken, then there's a risk that disgruntled employees could draw this to the attention of the enforcement authorities, which is the local authority or the HSE, to say that the employers have been in breach of their health and safety obligations to the workforce.
Absolutely, and I think it's kind of worth making the point already that actually we don't know whether having the vaccination actually stops onward transmission of COVID-19. That's not necessarily kind of guaranteed right now. So employers do have to think about that point when they're looking at kind of the health and safety steps. And it's not necessarily cut and dry. I think that people who've been vaccinated are immediately kind of not a a risk themselves to their colleagues. So, that may be a factor that has to be taken into account when you are looking at kind of workplace measures, and, justifying the steps that you take. And presumably, Oliver, as well, if you're kind of thinking about, having seating plans based on kind of who's been vaccinated and who hasn't, again, that could be implicitly disclosing information to colleagues, because you're quite clearly telling people who have and haven't been vaccinated.
Yeah, and I think when you're doing things like that, or really anything involved in collecting information about who has been vaccinated, it has that inherent risk that sort of by process of elimination, you're also obtaining data about who hasn't been. So yeah, I mean, something like that, that's the sort of risk that would be best dealt with in a data protection impact assessment and considered, and then you could maybe think about whether there's some mitigations that you can come up with.
Brilliant. Well, I'd just like to say thank you to you all. We've probably just about run out of time for our session today. Thank you very much, everyone, for asking brilliant questions. Apologies that we haven't been able to get through all of them today. But as I said earlier, we will be following up after this webinar with our kind of briefing note, which will be picking up on the points that you've raised in your questions, and we'll be trying to answer all of those. I would just like to thank Chris, Oliver, Alan. They've been a fantastic panel. Thank you very much for taking the time to speak to us today. I'd also like to thank Sophia and Melissa from our team, who have been working really, really hard behind the scenes, making the webinar flow as smoothly as it has done today. And finally, I'd like to thank you all for joining us, as I said, asking really great and interesting questions. You can see that this is a topic that will evolve and run, and it's really obviously something that we'll be keeping an eye on over the last few weeks. We'll be emailing out to all of you our follow-up briefing together with the slides that Chris and Oliver have put together, and we'll also send out to you a recording of the webinar today, so please do feel free to pass it on to colleagues who couldn't attend. We'll be hosting another employment seminar shortly in the next month or so, so please do look at the invites for that. In the meantime, I'd just like to thank you again for joining us, and hope you have a great day, and we look forward to seeing you all soon. Thank you very much.